So, for my Civil Liberties project, I decided to read Who is a Person in the Chapter 5 section. And this really, the first part that I'm going to talk about really goes into who is a person regarding the First Amendment right, and in particular, the freedom of speech. So it was going into saying that obviously people are people and they get, or American citizens, people are people within America, get that right, but does it also include corporations, children, and investment groups? And there is a case that was taken to the Supreme Court where a corporation in California was going in, they were like sending out letters to their people where they were putting political statements from people who didn't necessarily agree with them, and they put it in their letter to their supporters or people who are buying from them. And it was taken to the Supreme Court, and they said that is not under freedom of speech, obviously, because it could incite violence and stuff, because many people's political views don't match up with each other, and it just seemed inappropriate to include them, something political, with a utilities company. So they said no, and a direct quote from the Supreme Court was, "The identity of the speaker is not divisive in determining whether speech is protected." The court said that corporations and other associations like individuals contribute to the discussion, debate, and dissemination of information and ideas that the First Amendment seek to foster. In this case, the right to speak includes the choice of what not to say. So then there's a big exception to the free speech rights of corporations and labor union groups. When the McCain-Feingold campaign finance reform law passed in 2002, and like some civil liberty unions and other groups disagreed with this law. They felt that the law banned legitimate speech, and then for this law, or the law is that organizations cannot pay for electioneering communications on radio or televisions that refer to candidates for federal office within 60 days before the election. Then the Supreme Court got involved, and then they struck down these arguments, upholding the law in a landmark case, which is free speech and free press, with the McConnell versus Federal Election Commission. The court said that ads that only mention but did not expressively advocate a candidate were ways of influencing the election. And then it was revisited in 2007 when the court held the McCain-Feingold law could not be used to prevent an organization from running an ad urging people to write to Senator Feingold right before a primary election. And this is where he had people call in and told him which people they wanted him to vote for the judicial nominees. And that's where people, it was just weird, because that's not right. And then so for more who is a person, they go into moving on from corporations and what limits they have. They moved on to children, especially teens in this case. So there was a high school in 1988, Hazelwood High School, and they had a newspaper, and they would, in the student newspaper, they would write about teenage pregnancies and what divorce could do to a family, or what the effects of divorce are on like a teenager. And there was a principal that got involved and would censor multiple articles that they wrote, and then this got the students angry and thought that she was intruding on their rights, their First Amendment rights, and they sued her, and the court agreed that the students do not shed their constitutional rights to freedom of speech or expression at the school gate, and that they cannot be punished for expressing on campus their personal views. Oh, but students do not have the same rights as adults if those rights impede on the educational mission of the school. So the students they were allowed to express their rights and do their or have their First Amendment rights, but not if it's taken away from the school's mission, which is to educate. And yeah. So after that we know how complicated the interpretation of the First Amendment with the freedom of speech can be, we're going to now move on to the freedom of religion and church and state, and that's even more complicated. And most people aren't aware of how complex the legal interpretations of these provisions have become. So, to start off, the First Amendment clearly requires the separation of church and state, and what the amendment actually says is quite different, and people's interpretation of the amendment has broken down to two different clauses. The Free Exercise Clause, which is that Congress shall make no law prohibiting the free exercise of religion, and the Establishment Clause, which is more complex, which is Congress shall make no law respecting the establishment of religion, which could sound a little bad, but it makes sense as you explain it. Let's start with the Free Exercise Clause. So the Free Exercise Clause is the clearer of the two, shorter of the two, more straight to the point, simpler than the other one, and it's just the First Amendment requirement that law cannot prevent free exercise of religion. And examples of this is that Congress cannot pass the laws prohibiting Catholics from celebrating Mass, requiring Baptists from being Episcopalians, or preventing Jews from holding a bar mitzvah. So this is part of the First Amendment has been applied to the states through due process, and so pretty much the courts have treated religion like speech, where you could pretty much do or say whatever you want as long as it's no cause of serious harm to anyone. There's actually a event that occurred in Florida where there was an Afro-Caribbean religion called Santeria, which they would have animal sacrifices, and this basically went on to say you can't, they were fighting to keep their animal sacrifices, and it was said that you cannot ban animal sacrifices. The killing of animals is not illegal, it says in the book there would be no hamburgers and stuff like that, or rat traps would be illegal, and the ban in this case was clearly directed against a specific religion and was hence unconstitutional, so they kept their animal sacrifice. So having the right to exercise your religion freely doesn't necessarily mean you're exempt from some laws binding other citizens. Some of them are polygamy. Those are ones that mainly practiced by Mormons, and it's a law binding other citizens where you can only have one person or spouse, but this one has obviously more, or any religious reasons to oppose vaccinations or having blood transfusions. You don't have to get vaccinations, but if the state pushes out a mandatory vaccination law, the courts will not block them on grounds of religious liberty. And another one is an example they give is peyote, which is a drug that is used in religious Indian ceremonies, and if the certain state prohibits the use of that drug, then it's not going to be considered unconstitutional because the majority or everybody is banned from using it. So they said that in the book that public policy and religious belief are the hardest to figure out what's going on, and they give an example of war, like if you're being drafted, like that's going to be a concern if your religious morals say no. And they basically said if like you get drafted and there's like no peace or no rest in your soul or whatever, then you won't be, but you have to show signs that you're highly like religiously active or whatever. And it also goes on to give examples such as that if you're a Seventh-day Adventist and you don't want to work on Saturday and you get fired for that, but you don't want to like get another job, can you receive unemployment compensation? And if you're Amish and you don't want to send your kids to school after the 8th grade, like is that legal? And they both are. You have to give them unemployment compensation, and you don't have to send them past 8th grade. So next is the Establishment Clause. It's not as complicated, it's just wordy and you need to look into it. So it's basically, it stops Congress from making laws respecting an establishment or religion, which can get weird when you're looking at it, but it just basically means a wall of separation between church and state. It was created by Thomas Jefferson, who was opposed of having the Church of England established in Virginia. So he made it so no religion shall be established by law, and no national religion shall be established, whatever the states like tried to do and wouldn't do, and that the government cannot require a person to profess a belief in any religion, or cannot aid in any religion, some religions or all religions, and it cannot spend any tax money, however small the amount might be, in support of any religious activities or institution. So they are just in religious neutral activity.